Get a clean shot. All right. Today we're talking about a fun topic. I oftentimes come up with topics based upon what's happening with the team and all of that. And I've been having several of these transactions going on. And so I thought it would be good to talk about it. I've done some videos in the past with a law firm on selling a property with a tenant in it. And so I've put together a folder, which I believe Angela has shared. And there are several documents in the folder. There's a great big long one, which we're going to go over first. I mean, by long, it's like 45 pages. And before you're thinking, well, that's just insane, there's a lot of charts and things like that, and it could be a reference. I also created a document that you could share. If you're with my team, you don't even have to change the logo, with a seller that explains basically what the issues are. And because I'm that kind of guy, I also have one in Spanish. Right. And if I'm missing a language, Albanian or something that you want, have you ever heard of Google? But anyhow, so what we're going to do is we're going to talk about this. And I think you can all see my screen, right? Sure. Okay.
Yes.
So, have you ever heard somebody when they're talking about a subject talk about the landscape? What is the landscape about, this particular topic? And when I heard that phrase and I was thinking about this topic, to me, the landscape, think of it as a mountain range of volcanoes, like Mount Vesuvius, right, would be the kind of landscape. And what I mean by that is that this is dangerous, right? This topic is dangerous, and it's dangerous not just for buyers and sellers, but it's dangerous for real estate agents, because the concepts that we're going to talk about, courts have already held that are within the reasonable knowledge of a real estate agent. And the penalties, which, by the way, can apply to real estate agents, could involve as much as triple damages. Right. And so it's a topic you need to be careful about. And so I'm going to be going through it a little bit today and explaining what the issues are and what the options are and where the magma is likely to come bursting forth onto the surface. Now, for those of you that are more auditory than wanting to read, there's a deep dive podcast, which in and of itself is fairly long. I'm talking, it's like 37 minutes. And let's say you have insomnia. This is a good one, right? And it's actually it's very insightful. It's very complete. I'll explain how I created this handout as well as the deep dive podcast. I might as well do that now. All of the information that was the basis of this comes from either the California Association of Realtors legal department or from lawyers that I've worked with in the past that specialize in real estate, particularly landlord-tenant issues, right? The vast majority comes from the California Association of Realtors legal briefs, Q&As, etc. Now, there's a guide for homeowners, which is something that you could share with a homeowner. You'll see why. And I made a Spanish one just because I have free time on my hands and it wasn't that difficult. So, your fiduciary duty, right? The word fiduciary comes from the Latin word fides, where the word fido, like, the dog, comes from. And it comes from the same root word that fidelity and faithful come from, right? The reason dogs were called Fido is because they're faithful. Cats never have been called faithful, but dogs, yeah. So you have a fiduciary duty oftentimes, depending on which side you are, you definitely have a fiduciary duty to your client. So we're going to talk about what the issues are if you're a listing agent. And if you represent a buyer and they're buying property that has a tenant in it, you have a fiduciary duty, a duty of faithfulness, of fidelity to that client, and for which, if you violate, you could, well, be sued. And if you violate some of these laws, there's, in addition to the fact that you could be sued, and sometimes for quite a bit of money, I'll show you how that could happen, but also there's civil penalties for violating some of these rules. Notice, and I know some of this is a little long-winded, but I couldn't stop myself. The agent acts not merely as a facilitator for the seller, but as a mandatory compliance officer. Yeah. Did you know you were signing up for that when you got your real estate license? A mandatory compliance officer tasked with mitigating the significant legal and financial risks. Mismanagement means you could be sued. It also means you can include statutory fines and treble damages. So first of all, what makes this even more fun is that there's layers of overlapping law. So there is state law, there's the California Civil Code, there's some other laws that have been passed that are state law, there are even some federal laws that work their way in, but the real wrench in the machinery can come from what's called an RSO, and an RSO stands for a Rent Stabilization Ordinance, which, by the way, Los Angeles has, San Francisco, Berkeley, Alameda County has one. There's a bunch of them. And it's already been determined in litigation that a real estate agent is supposed to know whether or not there is a local rent stabilization ordinance in effect if you're selling property. And if you don't know, and therefore you don't follow it, and your client is damaged as a result, you're going to get sued, and they'll file complaints. How would you find out if there is a rent stabilization ordinance? Well, you could go to Google and you could ask, is there a local rent control law, rent stabilization ordinance, plus the various associations have put together local area disclosures. This is one of my big issues, right, with agents and others, is that there's oftentimes local laws that the agents don't know about, right? So and by the way, this is really easy to determine. You take an address of the property, and I usually go to ChatGPT and Gemini, but if you go to Google, you're getting Gemini anyhow, and you put in the address in Gemini or ChatGPT, and you ask, give me a list of all the local ordinances. In fact, I wrote a prompt for our transaction coordinator, Ra is her name. I wrote a prompt that you can put in the address and then just drop it in, and it comes up with everything that it can find that might affect that particular address. Because you're supposed to know whether or not they're local area disclosures, and you're supposed to check it, right? We're paid, most of us, professionally sized commissions, and they expect us to have professional knowledge of what we're doing. Who would have thought? Who would have thought? So a lot of times when we're going to be talking about this, the state law says one thing, but the local rent stabilization ordinance may say something different. And there's different levels of restriction. This might help you to remember which you have to follow. The most restrictive restriction restricts. How about that? Right. So whatever is the most restrictive, that's the one you have to follow. If the state is more restrictive, you have to follow that. If the local ordinance is more restrictive, you have to follow that. Even, and by the way, I didn't use San Jose as an example. San Jose has a rent stabilization ordinance also, right? There's a lot of them. Many cities do. You need to find out. If you're going to go on a listing appointment and the property has a tenant in it, it would be really good for you to ask the internet, is there a rent stabilization ordinance that affects this property? It just makes it more fun. The foundation is the California Civil Code. And the Tenant Protection Act, also known as AB 1482, that's the Assembly bill. Senate bill was 567. It was amended in 2024. It establishes a statewide baseline for residential rental properties. The two big things that are in the Tenant Protection Act are rent control and just cause eviction. And we're going to talk about when does it apply and what does that all mean. Now, to not wander too much into philosophy, policy, the majority of people in the state of California are renters. There's an argument which real estate organizations typically make that by having rent control and having just cause eviction, it discourages people from renting properties. And it does. And you're going to see as we get into this, oh, it does discourage people from renting properties, which, if you're looking at the abstract, would reduce the number of available rentals, which in the long term wouldn't necessarily help renters. But yeah, let's say you want to win an election and you know that 60% of the voters are renters, yeah, you might lean into what they want now, which is rent control and just cause eviction. Local supremacy is the strictest rule. Berkeley, San Francisco, San Jose, Los Angeles, all of those are generally more restrictive than the Tenant Protection Act, or the Tenant Protection Act. And some of the things, and this is not a complete list. Like I know San Jose has one, I didn't mention it. It's not a complete list, right? There's a lot of them. You're supposed to find out for your area. They might reduce the number of reasons for which you can evict somebody. They might have longer minimum occupancy for owner move in. This is called an OMI, right, which is generally an exception to the just cause eviction. If the owner moves in, that's sometimes an exception. It is an exception for the California Civil Code, but it's not necessarily an exception in your area, depending upon the rate stabilization ownership. Rate stabilization, what am I trying to say? Owner move in. That's what I'm trying to say. OMI. Exemptions from the Tenant Protection Act, also known fondly in the business as AB 1482. So these are what you don't have to follow the Tenant Protection Act if you meet these 5 major categories of exemptions. And they apply to both rent cap and just cause requirements. Number 1, new construction. Housing issued a certificate of occupancy, right? That's how they start the date within the past 15 years. It's a rolling basis. So that means it's not 15 years from when the act was passed. It's 15 years from today. So when was the certificate of occupancy issued? If it was more than 15 years ago, it's considered, or less than 15 years ago, it's considered new construction. You don't have to comply with the Tenant Protection Act. Single family properties and condominiums, if the owner is not a corporation. And REIT is a real estate investment trust, for those who don't know. LLCs, whatever, right? If the owner is an LLC, then it's not exempt. So do you think that there are potential clients that own rental properties that set up an LLC in order to handle the properties so that they keep it separate from their other income for tax purposes. Oh, yeah, people do that. And if you're a real estate agent and somebody says, well, I want to buy a rental property, what do you think? Should I get a LLC and run everything through it, or should I do it individually? Don't answer them. Tell them that they had to talk to a lawyer or somebody, because if you say, yeah, the LLC, that sounds like a great idea. And when they find out that now they're under this law that they otherwise would not have been under because you told them an LLC was a good idea, you could have to talk to attorneys, right? When they sue you for giving them bad advice. You understand what I meant when I talked about volcanic activity, right? Bursting out of the ground. Owner-occupied duplexes. So if you have a duplex and you live in one unit and rent out the other unit, you're exempt from the Tenant Protection Act. I sometimes get questions, well, what about an ADU? It's treated like a duplex. So if you live in it, either the ADU or the main house, and rent out the other one, that's still exempt. It's treated like a duplex. What about if I have a triplex and I live in one? You're not exempt. You're not exempt. 5 or more, whether you live in, you're not exempt. Single family duplexes, if you live in one of them. Institutional dormitories, property that was identified as affordable housing, yeah. However, having said that, local ordinances might not exempt you, right? Just because the Tenant Protection Act, the California state law, the civil code says you're exempt, that doesn't necessarily mean you're exempt. Because one of the things that the local ordinances have done is they've tried to unexempt people that were otherwise exempt. You would have to check. Now, what I wanted to do to make this a little bit, I'm at real time. So I created a table with the help of some other programs, and it just gives you an idea. Single family homes and condo, often exempt, not owned by a corporation. The missing an exemption notice, automatically covered. So in the forms that a landlord would give to a tenant, there's in the TOPA, the Tenant-Occupied Purchase Agreement Addendum, there's a box. And that box, if you check it, says that you as a landlord are exempt. Now, let's say you're a owner of a rental property and you got your lease agreement from Zillow or some other place where you downloaded it from the internet. And first of all, it may or may not have the disclaimers required under the Civil Code for the Tenant Protection Act. But one of the things that's required is if you're exempt, you have to notify the tenant that you're exempt. They have to sign something that says, I realize you're exempt. And I see a lot of homeowners who are renting out property who got their lease agreement from God knows where. And it doesn't even have this notice, plus it was never checked. So even if you are exempt, if you don't tell the tenant you are exempt and get them to sign something, you're not exempt anymore. Now, if you're wondering, well, I blew it, I used the Zillow rental agreement, rather than the California Association of Realtors form, because it was easy and they had it right there. And, yeah, but you can give them a notice now and get them to sign it, that notifies them that this is an exempt property. You don't have that notice, you're not exempt. Does everybody understand that? By the way, if you yell out questions, otherwise I just keep going. Multi-units, yeah, you're covered. Duplex, it all depends. The new construction, I already covered most of this. Right? So fixed leases. The other question is, let me just start with something before this, just for fun. I should have made this a poll, right? See how you guys would have done. Two forms. One is called the Residential Purchase Agreement, California Association of Realtors form. Form number 2 is called RIPA, R-I-P-A, the Residential Income Purchase Agreement. You have a client, a buyer, making an offer on a condominium that is currently rented out. Which form do you use? The Residential Purchase Agreement or the Residential Income Property Purchase Agreement? Which one do you use? Well, and most agents, I'm sure you guys are at a much higher level because you come to my classes. Most agents says, well, if it's a single family home, condo, townhouse, I would use the Residential Purchase Agreement. Yeah, and you can do that. And you could attach the TOPA form. But you also could use the Residential Income Purchase Agreement. And the dialogue I would have with the client is the buyer, do you plan on leaving it as a rental? Yes. Are you doing it because you want the rental income? Well, of course. It's an income property thing, right? Many agents think that the Residential Income Purchase Agreement is what you use on fourplexes and things like that. It's actually designed for any residential income producing property. Now, there are differences because the default sections in the Residential Purchase Agreement for possession and that sort of thing are different from the ones in the Residential Income Purchase Agreement. You don't need the TOPA form, which I have given you a copy of. We'll talk about that later. If it's an RIPA form, because it already has that information in it. Just saying. Is the current tenant's lease a fixed term lease or is it a month to month? If it's a fixed term lease, it's the legal phrase is it runs with the land. Another way to put it, if you buy property and there's a existing lease, you're buying the property subject to the existing lease. The sale of the property does not terminate the lease. Still in effect. And whatever the rent amount is, whatever that original lease said, that's what it's going to say to you. And by the way, it doesn't matter how long they've lived there. Even if it's only 2 months that they've rented it, if they have a 1-year lease, you can't kick them out for a long time probably. But you're stuck within that year because you're buying it subject to the lease. If it's month to month, it either could have just cause protections or it might not have just cause protections. If it doesn't have just cause protections, you could throw them out with 30 to 60 days notice. Why? The choice depends on how long they've been there. So let's say it's a single family home, it's exempt from the Tenant Protection Act, and the current tenant has been there for 6 months. You can give them 30 days notice and make them leave. If they've been there for a year or more, you have to give them 60 days notice. Now, if it is covered under the just cause eviction, there's 15 reasons that you could evict somebody under the just cause, and the I want to because it'll be easier to sell my house is not one of the 15 reasons. You're going to have to prove that they did something wrong, that they broke the lease, that you're going to move in, that you have to renovate, all of which we've covered in this.
Pua has a question, Mike.
Question.
Pua says, if the person as buyer wants to occupy the home, wouldn't that provide an opportunity to term the lease? I think you went over this.
Yes, it's coming up in a later section, but that's called the OMI exemption to just cause eviction, which is the owner is moving in. And that is an exception. But there are restrictions. which we're going to talk about. So how about this, though, related to that? We're in contract. The buyer is intending to move in. There's a tenant in it now. Can the current homeowner give that tenant the required notice, let's say 60 days, because the buyer is intending to move in? And the answer is no. Why not? Because the owner of the property is not intending to move in. And that buyer, until escrow closes, is not the owner. So the buyer has to close escrow and then give 60 days notice to the existing tenant, saying, I'm going to be moving in, or a relative. And there's a list of what that, cousins aren't on the list, but children and grandchildren are on the list. Any questions about that? All right. Pre-listing. I'm going to move a little bit quicker because I only have 40 more pages to do. Before, when you list it, before you put it on the MLS, you ought to determine whether or not it's under what kinds of rent control. Things that you would want to verify. What is the structure of the lease? Fixed term, month to month, occupancy length. I just helped a client rent a property, and we rented it for 11 months. Why 11 months? Because at 12 months, it changes the rules. And 11 months gives you enough time to figure out if you like the tenant. Less notice is required, to have less rights. How long has the current tenant been there? And is there an exemption? Okay, let me, and so here's like an audit checklist. I'm not going to go through that again, but you get the idea. This is, and you can put all these together. It would be a lot shorter, but I'm making this sort of as a, a reference document. All right, now let's get to the real issues that affect agents. So the tenant is in the property now. If the property is exempt from just cause eviction, in other words, it's a single family home, as the most common example that's being rented out. Now, what sometimes the homeowners will say is, well, I don't want to kick the tenant out. They're paying rent, right? They're going to pay rent. So let the buyer kick them out, but I want the money. Now, I explained to them that and I'm in a Silicon Valley market, which is relatively expensive. This could cost you like 50 grand. This could cost you a lot of money if you don't get the tenant out. You want to get the tenant out. Let's say the tenant doesn't want to get out. You need to bribe the tenant to get out. Okay, I don't want to do that because I like the rent. So now you have to bribe the tenant to cooperate with the sale. How would you do that? Pay them something for every showing they allow. Pay them something for every open house they let you do. Pay them a bonus if escrow closes. And by that, I mean 5 grand, 10 grand. And if you're thinking, well, that's too much, wait till you see what the results are. Because if the tenant doesn't want you to show the property, there's not a lot you can do. Oh, you can give them notice, we're going to come by. What if they don't let you in? Can you just let yourself in? No, you can't do that. Can't have a lockbox on the property, right? Can't have a lockbox, right? You schedule open houses and the tenant says, oh, we're not feeling really well today. This isn't a good day for us. Maybe next weekend. You can't really do anything. Now, you could try to evict them because most leases contain a clause that says they'll cooperate. At least the California Association of Realtors one does. I don't know which lease. I always want to see a copy of the lease. I've seen just some really ugly old leases that people have, and they don't have any of these protections in it. There's mandatory notice requirements to show the property. Presumed to be 24 hours. The code doesn't actually say 24 hours, but courts have ruled that that's considered reasonable. You have to, and by the way, CAR has a form that you could use the exact date, the approximate time, and the purpose. It has to be during normal business hours. Now, there have been court cases that have ruled that open houses on the weekend are normal business hours for real estate agents. By the way, the tenant has a right to be there, to watch you, to follow you around while you're showing the property. Try and shut them up, right? Does everybody understand that having the tenant in there resisting the showing of the property, resisting open houses, not changing their mind at the last minute, following you around when you're trying to show the property, is this going to have an effect on how soon you're going to sell the property and for how much money? And it could cost a lot. And you'll find if you look at expired listings and things like that, a large percentage of them involve tenants being in the property. They just wouldn't let it be shown. Hence, bribe them. Say, if you cooperate and it closes, I'll give you $5,000, $10,000. What will it take? Right? Let me do an open house. I'll give you $100, $200. Let me do an open house. You understand how this starts to add up if you're the owner of the property. You can do 2 per month, according to the case law, right? Again, this has been litigated in courts. So if the tenant is in the property, and by the way, tenants get free legal advice. It's not just the internet. There's all these legal people that will help them and tell them. And by the way, I've been doing this a long time. And listing agents that are on my team will say, yeah, well, the tenants are there. And I say, get the tenant out. No, they don't want to get the tenant out. They've been there a long time. They're really friendly. They know we're selling it. They're going to cooperate. And I'm like, get the tenant out. No, you don't understand. These are nice people. I met them. 10 days later, we get a letter from a lawyer saying, how dare you treat my client this horribly? You can't, we don't want you to show the property. You have to, all of a sudden, all of their rights start bubbling to the surface. They always say that at the beginning. Get them out. Whether it costs money to give them out, get them out. Right? And tell them, look, you're going to have to get out because the buyer is likely to buy the property with the purpose of living in it, which means you're going to have to move. Now, there's a relocation allowance you have to give them. You're going to have to offer them more than that. The relocation allowance under the state law is 1 month's rent. Local ordinances may raise that. So if they're paying $3,000 a month, let's say, in rent, and you offer them $500 to get out early, they're going to laugh at it. $5,000. $6,000, $10,000. It's called cash for keys. You need to, if you really want to sell the property and get the most money, you need to get them out. And they can give you alternative times. Well, we like to show the property at 3 o'clock on Thursday. No, that's not going to work for us. Right? There's a TV show we like to watch together at that time. Maybe, some other day. Let me know. And again, I have a chart. Right, and this is a general notice, but you get the idea. You have to, you're allowed under the civil code to enter the building to show it to prospective tenants or buyers. You're allowed to. You need a fresh written 24-hour notice for every showing. Right? Can't just give them one that says, here's the 5 times we're planning on showing this week, every single one. Yeah, every showing. You can't just call them up, text them. That's not good enough. There has to be a written document that you provide to them answering all these different questions. Right? You can give them a verbal notice 24 hours in advance, but it's allowed only if you've already given them a written one. And you can leave it inside. Now, again, CAR has forms for this, of which I've given you a file that has copies of them. Notice of entry is the CAR form. Tenant's right. The tenant has a right to be present. They have the right to refuse. You say, well, I gave them 24 hours notice. I told them the exact time. Everybody's here. They say, I don't feel like it. They won't let you in. You can't force your way in. You have to go away. Right? Lock boxes are not allowed unless they consent. Try and get them to do that. Oh, do you mean anybody can come in anytime they want to because they have, well, a real estate license? No, right? They rarely will do that. Hostile or uncooperative tenants can drastically reduce showing availability and harm market value. This is the conversation you have to have with the seller. You think you're saving money because the tenant is paying you rent. You're going to lose a lot more than that because we can't show the property and they won't cooperate. Do you think they'll keep it clean? Do you think they'll open all the blinds and turn the lights on and do all the other stuff you would normally do? Do you think they'll not have smelly things going on in the they're not cooperating. They don't want you to sell it. And if they don't want you to sell it, there's a lot they can do to make it difficult for you to sell it. Incentivizing. I've already mentioned this. Cash bonuses, rent reduction, gift cards, paid cleaning, right? I don't want to, we'll pay to have somebody come and clean your place. Hotel accommodations, flexible scheduling arrangements. If you can get them to cooperate, everything is going to go easier. Of course, it would be better to just get them out, right? If you can't get them out, well, then you want to buy their cooperation. And I have a little chart on this. So these are just some examples of what people are doing in the business. Giving them a bonus for every showing, rent reduction, gift cards, cash for keys. By the way, in some areas, in some markets, it could go way above $6,000. It depends on how much rent are they paying. Generally, the cash for keys is greater than the amount of the monthly rent. It has to be greater than the amount because they get a month's rent to leave in relocation if it's covered under local or state ordinances. Transactional disclosures. You're required by law, and by the way, this is mentioned in the TOPA addendum. If you're the seller, you're required by law to disclose all of this to the potential buyer. Now, this, by the way, is whether you're under the Tenant Protection Act or not. This is just required disclosures, copies of the leases and rental agreements, a statement and rent history, date of the last increase, concessions or rebates, delinquent amounts, income and expense statements. Say if the buyer is buying the property because it produces income, they want to know all of this. And it's covered in the RIPA, the Residential Income Purchase Agreement, and it's mentioned in the TOPA form. Official notices. Seller must disclose where the unit is subject to local rent stabilization ordinances or the statewide Tenant Protection Act. So if you're selling property with tenants in it, I'm sure you do all that, don't you? Don't you give all that to the buyer so they can read it? I'm sure you do. So I have a little chart explaining that. Security deposits. If mishandled, both the buyer and seller are liable for joint and several liability. That's not misspelled. The word several here doesn't mean several like in many, it means severed, as in severed off. So what joint and several means is that if the security deposit is mishandled, the tenant could sue either the seller or the buyer or both. If they sue them both, it's joint. If they pick one and go after that one, it's called several liability. Severed. So as of July 1st, 2024, the maximum deposit is 1 month's rent. Furnished or unfurnished. The old rule said it was 1 month if it was furnished and 2 months if it was, unfurnished and 2 months if it was furnished. That's gone. There is the small landlord exception. This has nothing to do with height. That's not the small landlord, but it means if you don't own, and I think I have later the example, but if you have 2 properties and you live in them, you're a small landlord. If you have 1 property and you rent it out, you're a small landlord. If you have a triplex and you're renting out 2, you're not a small landlord. Fourplex, not a small, you get the idea as it goes up. So what can you do with the reason we're talking about this is the security deposit is not the owner or the landlord's money. It's money that belongs to the tenant that the owner or landlord is holding in trust for the tenant. So the current owner has the deposit in their bank account someplace. And that either needs to be refunded to the tenant when the property is sold or transferred, done through escrow, to the new owner when escrow closes. What can you use the deposit for? Unpaid rent. Normal wear and tear is not something you can use it for. It has to have damage. So for example, well, the carpets need to be cleaned because they're old. That's normal wear and tear. Well, the carpets are old and we're going to replace them. That's normal wear and tear. The children drew a mural on the wall. That's damage, not normal wear and tear. Cleaning to move in level. That does not mean you have to have it professionally cleaned. People say, oh, it has to be professionally. No, that's not what it means. There have been very few court cases on this, but it generally is held that it has to be broom clean, free of personal property and debris. That's it. What about, don't they have to shampoo the? No, not necessarily. Now, if you could prove that the carpets were dirty beyond normal wear and tear, they're, they're 4 Dobermans, that's, you have an argument. But it's not, nowhere does it say you have to have them chem dried or it's not, it's just basic move-in level cleaning, replacement of keys, other tenant defaults. So the deposit either has to be returned or transferred to the new owner, done through escrow, and there's a thing about that. A tenant estoppel certificate. This is verification from the tenant as to how much rent they're paying and how much the security deposit is. Now you might think, well, they already know that because we have a copy of the lease. Nah. So what happens is that the tenant is paying $3,000 a month. A new apartment building opens up not too far away, and the tenant comes to the owner and says, look, I could rent one of those apartments, brand new, for the same amount I'm paying you. But it's brand new, and they've got a pool and stuff you do not have. So if you don't lower my rent to $2,500 a month, I'm walking, and I'm going to go to that new apartment. Landlord says, okay. Almost never do they redraw the lease. They don't. I'm just telling you, they usually don't. So the tenant is now paying $2,500 a month, but the lease has $3,000. So the owner turns over to the buyer copies of the lease. They say $3,000, but that's not what the tenant is paying. So how would you know? You have to ask the tenant. The owner says, I only have 1 month of a deposit. Well, when the tenant is leaving, they're saying, no, I gave him 2 months. I can prove it. I got the check here. So the tenant estoppel certificate is a form that the tenant would fill out that answers basic questions about the property. It's in the, now, sometimes they don't want to. They don't want to. Most, if you're using a good lease, like the California Association of Realtors form, it contains a clause where it says that the tenant is obligated to fill out one of these forms if requested. But if you just download something from the internet because, hey, you don't need a real form, it's just a tenancy and it doesn't include that, then the tenant could say, well, I don't want to do it. Don't bother me, I ain't going to do it. Now, do you understand under most of the agreements, under TOPA, which would modify the residential purchase agreement, or under the residential income purchase agreement, receipt of this is a contingency. And if you can't provide it, the buyer can back out or renegotiate the price. Because the buyer is going to say, well, wait a second, I'm buying this for income purposes, and you can't verify what the income is. You just can't do it because you can't get the tenants to fill this out. So now we're back to bribing the tenant, right? Either if it's in the lease and they refuse to do it, that could be considered grounds for eviction because they're not fulfilling the terms of their lease. But if it's not in the lease, which it isn't in a lot of them, the ones you get on the internet oftentimes don't mention this at all. The tenant just says, I ain't going to do it. All right, it's a contingency. It certainly can be. And there's a little chart, right? And what if they won't do it? Buyer can cancel, buyer could renegotiate, buyer could just say, okay, I'll take the risk and go ahead. The seller can't guarantee, but they have to try. Vacancy, we want them out. Does everybody get that point? We want them out, right? It's a lot, especially if it's a single family home, we want them out. Cash for keys, bribe them. It's the most effective way. We'll give you money as soon as you leave. Give us the keys. We can make sure you didn't steal, break, or otherwise damage the property. We're going to give you $10,000. It has to be enough, right? Because remember, they're going to get a relocation allowance. They might if they qualify. You have to get them out. Now, if it's an exempt, like a single family property, and you're not a LLC, right? You're not an LLC, and it's a single family, it's exempt, just want to mention that again, from the just cause eviction rules, which means you don't necessarily have to go through this. But yeah, we want them out is not a just cause. Exempt single family residences, give them a notice. If they're not covered by just cause, which a single family non-LLC would not be covered, give them notice. They've been there, it's month to month, they give them a 30-day notice. If occupancy is longer than a year, by the way, month to month or not. So if somebody has been living there for more than a year on a month-to-month basis, they are been there for more than a year and you have to give them 60 days notice. 30 days if the property is in escrow with an owner-occupant buyer who will move in for at least 1 year, right? If the property is exempt, right? If it's not exempt, you can't kick them out for that, and they're going to have a charge. If it is covered by the just cause, 12 months, all tenants, 24 months with at least one tenant. Now, the reason for that rule is, let's say I've been there for 2 years, but I bring in a co-tenant and they've only been there for 1 month. And the landlord says, aha, they've been there for less than a year, I can throw them out. Not so fast. If the primary tenant has been there for 2 years or longer, that basically makes up for the other recently added tenants. Selling the property is not a legal reason to terminate the tenancy if it's covered by just cause. What are the no-fault paths? Owner can move in. Ellis Act withdrawal, we'll talk about that. A substantial remodel, you need building permits. You just can't say, oh, we plan on remodeling it. Now, flippers, right? If the flipper is doing this, they can buy the property. They're not moving in, but they might tear the place apart. That would be a substantial remodel. There's still, you have to give them relocation allowance and whatever, a government or voluntary cash for keys. And I have a summary. Cash for keys, this is the easiest way to do it. Bribe them, get them out. Once you've got them out, you can clean the place, you can paint the place, you can fix things, you can stage it, you can have pictures taken, you can show it all the time, you can do open houses every weekend, and the amount of money that they're likely to get is going to exceed what what they lose from the rent. And I have, cash. So owner move in, a buyer or a qualifying relative. And there's a list, I don't know if I put it in here, but it has to be a family member. That again could be children, grandchildren, whatever. They have to move in within 90 days and they must be there for 1 year. What if they leave early? Job changes or whatever, they're supposed to offer it back to the original tenant at the same rent as before. Yeah. And you have to give 60 days notice. You have to tell them who's going to move in, what their relationship is, and include your relocation assistance. And I have a chart about that. Penalties for non-compliance. You have to rent it to back to the original tenant. You have to reimburse moving expenses. Tenant can claim treble damages if they think that you did it purposely. You lied to them. And if they get an attorney to sue you, you're going to end up often paying the attorney's fees. Ellis Act is you don't want to rent it anymore to anyone. You own it, you're not necessarily going to move in, but you just decided you're not going to rent it to anyone. And if it's a multi-unit building like duplex, triplex, fourplex, all the units have to be withdrawn. You have to give them a notice, 120-day notice, and seniors, which is defined as 62 or older, disabled tenants, households with children, you have to give them a 1-year notice before you can withdraw it from the rental market. And local RSOs oftentimes require more stuff. And they also, by the way, if you re-rent it, because you say, well, I'm going to withdraw it from the rental market till you get rid of everybody and then you change your mind, you're going to meet lawyers if they find out. Right? If the tenants find out, like they're looking on Zillow rentals and they see the property you said you were going to withdraw, and there it is. Substantial remodel. It has to be substantial enough that it would require 30 days of vacancy. You have to have the building permits. You have to have it has to involve structural, electrical, plumbing, mechanical systems. Can't be cosmetic. The notice that you give to the tenant has to include a copy of the building permits. If you don't have building permits, that doesn't qualify. And the tenant must be offered the opportunity to return if the work is not completed. You better do it, right? You just can't say and go, I went and got the building permit so we can kick them out now. And I have a description of that as well. Mandatory relocation assistance, only for no fault terminations, which is this group here. If they're at fault, you don't have to give them relocation. Usually it's 1 month, right? 1 month's rent is the relocation assistance. Local RSOs have more. Berkeley, God bless them, it's $19,000. Los Angeles, it depends upon the kind of tenant. It could go over $20,000. Now, do you understand how much would you have to bribe somebody in LA or Berkeley to get them to move out voluntarily when they figure out that they have this much coming to them? You're going to have to beat that. You're gonna have to beat that. And again, this isn't everything. I just picked one in Southern California and a couple up here, but there's a lot of other local, you need to figure out what they are. This is about the cash and the rent waivers and things like that. You can give them a cash payment. This is how do you pay them for the relocation? You could waive the final month's rent. That would work, and I have a little chart. If you don't comply, you're in trouble, right? They're gonna sue you, they're gonna file complaints, you could have to pay attorney's fees and treble damages. It's just ugly. It's just ugly. And I know I have a lot of charts, but I expected that you might, some of you might want to read it. And then this is more about managing it. This is a pre-listing compliance checklist. Some of the things that you might want to look at. This is a summary of what I was going on about the marketing and showing phase. Different scenarios for cooperation. How do you handle the escrow? All of that sort of stuff, right? Now, what I've also included is, I don't know, where is it? Is my folder empty? I don't know. Did somebody take? I don't think so. My folder is empty. Did somebody delete all the files that are in the folder? I didn't. I think there was a view only. The only one that has the ability to do that, I don't know where they went. Oh. I'm sure Angela didn't remove them, but I don't know. Selling tenant occupied property. This looks like it. There it is. I don't know. So I've created a document for, this is something that you could share with a homeowner that sort of summarizes a lot of this. Some of you will be happy just to read it. And this is, for those of you that are nerdy about this is a copy of the forms that we talked about, which you might want to familiarize yourself with. This is, and included in this is a sample letter. This is it here from the California Association of Realtors Legal Library that discusses about the security deposit and what are you planning on doing with it when you're selling. And then this is a form that would go along with that. And if you're on my team, I would expect you to talk to me, right? Talk to me about this. Talk to me, right? Any questions? Angela, is there anyone there that had, no? All right. I don't see questions. Everybody's left already because it's time to leave. I have to go to a CAR legal webinar now. I do that so you don't have to. Next week, we're going to be talking about something else fun, but I'll surprise you. And by the way, leave me a review. You saw that. Leave me a review. There's a link for that. Leave me a review. I appreciate it. Thank you. Bye, everybody.